the state has to be able to, in effect, disprove a reasonable hypothesis of self-defense. Even in the light most favorable to the state, all of those standards that the state has to present, all the factual scenarios have to convince this court that a judgment of acquittal should not be granted because they have presented evidence which negates every hypothesis of self-defense or hypothesis of innocence, which they're synonymous for these purposes, that my client acted in self-defense. Failing to do that, Walker is the law of this land and suggests that a judgment of acquittal should be granted. If it is not granted outright because they have simply failed to disprove self-defense, of course you know that to be the standard for the jury to consider anyway, then we shouldn't even need to present a defense. And if for some reason, as I mentioned a moment ago, you think that all of that is just has to be ruled in favor of the state, not giving my interpretation to Walker and its progeny any consideration whatsoever, then certainly the state has failed in convincing that second-degree murder charge, evidencing a depraved mind, has any basis moving forward to this jury because they simply have not presented any evidence to suggest that there is not a reasonable hypothesis that my client did not act with ill will or hatred, and that they need to present, though they get the benefit of all the evidence being presented in their favor, that what they don't get is the benefit of you ignoring evidence that can't be interpreted any other way. You cannot look at that picture of my client's nose and say that he wasn't beat in the face. You can't look at the back of his head and say he wasn't beat in the back of the head. You cannot look at the autopsy of Mr. Martin and realize my client never attempted to, nor landed one blow upon Mr. Martin. All my client did was scream out for help. Mr. Good, though he was questioned a lot about this area, did finally, I think, opine, though he didn't see gas escaping from my client's mouth as he was the one screaming towards him, that he said that it was his thought and his common sense that it was, in fact, my client screaming out for help. And the reality is, had it been Mr. Martin, who we now know, and it's undisputed, was on top screaming for help, well, he had his chance. He had Mr. Good 17 feet away, asking him to stop, telling Mr. Martin he was going to call 911, and Mr. Martin continued to ignore him and continued to batter my client in whatever form or fashion, or however number of times he did, that ended up with the injuries that my client had. They can't ignore that evidence to a jury, and they really should not be able to ignore it to you on a judgment of acquittal argument.
On behalf of the state, Mr. Bedtime.
Thank you. Respectfully, Mr. O'Mara gets the arguments backwards for starters. Because justifiable use of deadly force is a defense for which the defendant actually bears the initial burden, and I'm not arguing necessarily that he didn't meet it, but because it is a defense, the first inquiry that has to be undertaken is the elements of the crime itself of second-degree murder. Only then do we move to the issue of whether or not there is sufficient evidence to dispute the defense of justifiable use of deadly force. So the first thing that should be addressed is the elements of the actual crime that the state bears the burden of proving. The intent and state of mind. Included in the court's materials, and I think it's probably either the last or second to the last case in the packet, is a case of Gibbs versus State. It's 904 Southern 2nd 432. It's a 2005 opinion from the 4th District Court of Appeal. Beginning at the bottom of the first column of page 2 and continuing through the midpoint of the second column, the courts have held for a long time that when we're talking about evidence of will, spite, or evil intent. Pointing a loaded gun at the victim and firing it is an act imminently dangerous to another and evincing a depraved mind regardless of human life. Pointing a loaded weapon at their direction, at their head, at their heart, and pulling the trigger is in fact, by itself, evidence that you have ill will toward your target. There's really no question of that. Shooting someone in the heart is by itself, on its face, evidence of ill will. Now, the defendant raises a defense saying, I was justified in doing so, but he's certainly not saying that at the time he pulls that gun, points it at Trayvon Martin's heart, and squeezes the trigger and puts a hollow point through him, that he had some kind of benevolent intention. There's only one reason you squeeze the trigger at someone's heart, and that's because you mean to kill him, or you don't care. So the first issue is there evidence in this case of intent and spite and evil will? I submit Gibbs makes it very clear that even just given the gunshot, there's evidence of that. But let's talk that there's plenty more. We'll talk about, and I'll briefly reference the Walker case, which I'll point out is absolutely not a self-defense case. It's a whodunit case. And so when Mr. O'Mara says it's the law of the land in the analysis of the case like this, I disagree. It's not. Because it's not a self-defense case, it has zero application to at least half of this argument. But for starters, the court said this is not a purely circumstantial evidence case. Neither is this one. Evidence of this defendant's ill will towards Trayvon Martin in particular, Mr. O'Mara cast it as it's usually people who know each other. Well, the problem is this defendant thought he knew. He thought he knew. He thought he knew Trayvon Martin as one of these assholes who get away. He thought he knew Trayvon Martin as a fucking punk. He didn't know Trayvon Martin, but he thought he did. Because this defendant had enough in his heart to stop his trip to the grocery store, if that's in fact where he was going, to follow Trayvon Martin as he walked through the neighborhood in his car, to get out of his car in the rain, follow him, and then, as the witnesses make clear, pursue him and make contact with him and grab him. He had enough in his heart to do all that. So we'll talk about first the direct evidence. The direct evidence, and even the Walker case supports this, the defendant's confession, a defendant's statement, is direct evidence of his state of mind. This defendant's statements go a long way towards telling us what that was. I've already mentioned his conversation to Mr. Nofke in the non-emergency call. But we go further than that. What other things has he said about this? And I'll ask the clerk in advance if I could have States Exhibit 210, please. He talks about, the first description is he thinks he's on drugs and he's suspicious because he's walking in the neighborhood. He also says that he would do nothing differently, and this is all part of God's plan. And I don't even need Exhibit 210. I'll tell the court what it says. The first line of the first homework assignment he wrote for Professor Carter indicates that the reason he wants to be a law enforcement officer, in that case I think it was U.S. Marshals, because he wants to hunt fugitives and make sure they don't get away. Those are direct statements of this defendant. That's not circumstantial evidence. The defense can argue as to how they ought to be interpreted, but they are in fact direct evidence. You move from that to the statements by Rachel Gentile and Ms. Bahadur, Ms. Mora, and Ms. Serdaika, that all indicate that there was some pursuit that took place, and one does not follow somebody wishing them well. One does not grab them or confront them or ask them what they're doing here because you like them, but because you have some kind of ill will, some kind of spite, some kind of bad feeling towards them. The central question, as it relates to that, and I'll further point out that at least Ms. Gentile said she heard the victim in this case tell the defendant to get off. The only hypothesis of innocence as it relates to all this is in fact justifiable use of self-defense. They're not even pretending that this defendant did not kill Trayvon Martin. So the only hypothesis of innocence they offer is that. So I've covered what I believe is the direct evidence of this defendant's guilt as to his state of mind. I will now talk about the circumstantial evidence. There's the idea that he thought enough of his neighborhood watch program to trumpet it, to walk around and be proud about it, and that's fine, well and good, but the one time he actually comes in contact with someone, he doesn't bother to say, I'm with the neighborhood watch. Every time he's on the phone with the police, it's, I'm with the neighborhood watch, I'm with the neighborhood watch. The one time he's not, he doesn't bother. He follows even after, and it's contrary to the training for the neighborhood watch. There was a argument, I guess, or there will be an argument about whether he was told not to follow and what his perception of that was. The defendant wrote in his written statement that the dispatcher told him not to follow. His understanding was exactly that. We'll talk about some of his claims in brief, but he lies about kind of his whereabouts. Mr. Romero said that there's nothing to contradict the idea that he went right from the tee back to his car. There's 2 minutes of blank time in those phone records where this defendant is apparently wandering about the neighborhood. There's 2 minutes he can't account for. If he's to be believed that he is hit when he says he's hit, the phone records prove that he had plenty of time to cover whatever distance it was, and he says he never got more than 100 feet from his truck. Number two, he keeps changing the meeting location for the police. I mean, that is circumstantial evidence that he's got something else in mind. He wants the police to meet him at the clubhouse. No, okay, go back from the clubhouse, just meet me at my truck instead. Okay, never mind altogether. Just call me when you get here. I'm not going to meet you. You find me. That's not evidence that he is interested in getting to the police right away, nor is getting out of his car in the first place evidence that he is interested in meeting the police there. What it is evidence, circumstantial at least, that he was going to ensure, because the police have always been too slow to catch these guys who always get away. They've always been too slow, and he's going to make sure that this time something stops them from getting away. The one other time that somebody got caught had nothing to do with him. It had to do with the stucco guy who followed and identified and thereby caught the burglar. And the defendant knew it. The inconsistencies in the defendant's own statements are hardly minor. I think viewed in favor of the state, which the court is required to do, and construed in the light most favorable to the state, they're evidence of somebody who can't figure out which lie he's already told, so he tells a new one. He jumped out of the bushes. No, he didn't jump out of the bushes. He was right there where you are standing in the video walkthrough. No, he's not right there where you are standing. He actually, after I hung up the phone and turned around to walk back to my truck, he was walking toward me. He says all three of those things. They can't all possibly be true. I'll submit probably none of them are true, but the bottom line is he keeps contradicting himself, and not just in some minor fashion. He claims that he knows all of his neighbors, but I don't know